Civil Judge Junior Division and Law Examinations in English Language. Special lecture to clarify the doubts from my student friends on various issues is the topic for discussion today. Dear student friends, I started uploading lectures designed to candidates appearing for Civil Judge Junior examination. These lectures are not only useful to the candidates appearing for Civil Judge Junior examination, but also to all students of law, graduation level and LLM level also. I am making every sincere efforts to place before you the latest developments to the best of my knowledge and collecting from different sources. Here, what I wish to tell you is many students are through their comments expressing their doubts, and some students asking me over phone uh, expressing various doubts on various issues. Instead of giving clarification to each and everyone individually, I wanted to clarify in general. I am giving some tips in this lecture to be born in your mind to be a successful advocate tomorrow and a successful judge day after tomorrow. Now, let us come to the topic. The Civil Judge Junior examination is conducted by the high courts of almost all states and union territories. You know, we have 28 states and 8 union territories. Two union territories, Delhi and Jammu and Kashmir, are conducting this examination. The high courts giving notification are through the public service commissions of the respective states giving notification. I have gone through the syllabi of various notifications of uh, civil judge junior examination, and I enlightened it previously. Again, I will give overall idea. I won't give any more lecture on these suggestions and clarifications. You please make note of it. Here, when an individual, when a student wishes to become a judicial officer or a well, good advocate, distinguished lawyer, he must possess sound knowledge in almost all branches of law. To be a successful lawyer for earning money is not criteria, and you must possess sound knowledge. Then only you will be able to maintain good respect in bench and bar. So, as a law student, during study career, during student career only, you will have ample of time to learn the subject. If you treat your legal studies, student career for life enjoyment, you don't learn subject, that is, don't attend classes regularly, don't read various subjects punctually, and somehow or other you manage it to read something before exams and get to the exam and then enter court as an advocate, you will have to face lot of problems, and you may be looked down in certain instances. The reason is, when once you came out of the college and enter court as a legal professional, you won't find any time to learn the subject. you join as a junior advocate with some senior advocate, and whatever work that senior advocate entrusts, you will become busy in that area. You don't find any time to learn subjects. That is why the option is you must you must attend classes regularly and learn subject. And even you could not attend classes regularly read punctually, the only option is after becoming an advocate, enrolling an advocate, you start your career, if you possible, as at high court headquarters, where you can have competitive examination centers. Competitive, your college is best platform to learn all the subjects. In case you would not able to go to college regularly and learn subject properly, the next option is to join some competitive examination center, where you can have lot of enthusiasm and inspiration by looking at the preparation and talent of other candidates appearing for the examination. No competitive center may be able to give complete coaching on almost all 3 years course subjects. However, they have consistent experience and knowledge over the conduct of judicial service exam by various states. With their experience, they will be able to give you crash coaching, and they conduct mock tests, and they will let you know how to translate, how to write essay. All these aspects they will enlighten you. It is not possible to complete number of subjects which the student is expected to learn during 3 years of LLB course in a few months of coaching in competitive centers. They will do their best. That is why, as a student, you may not have that inspiration to work hard. You want to enjoy the student life, but in competitive center, all students, candidates will interact. When all students are possessing very good knowledge and you don't possess proper knowledge, naturally you will get activated and inspired. I too must work hard and learn subject. So when once either you whether you took your legal studies very seriously and acquired enough knowledge during law course, that is 3 years, that still you will have to join some competitive exam center for these judgment writing, mock tests, and all these things. So the pattern of then only, even if you get selected as judge, it will be, you should be very happy. Even if you don't get selection as a judge, you need not get disappointed, because you can return to the court as a full-fledged knowledgeable legal knowledgeable advocate. You can enjoy very good uh, social status. So this is, dear friend, the very purpose of uploading my lectures, law lectures, in YouTube is to enlighten my student friends to learn subject, and to suggest them to give respect to our most prestigious noble profession. Now, dear friends, our students are asking so many questions and so many things. Consolidating all these questions, I am giving you some tips. Here, every judicial service, that is civil judge junior examination, is conducted by various states, comprises of three parts. First part is preliminary exam. Part 2 is main exam. Part 2 main exam comprises of two parts overall. One is written exam, second one is viva examination. So almost all states conduct this preliminary examination to shortlist the candidates. Whatever subjects are prescribed for study for preliminary examination, the same subjects will be prescribed for main examination and interview. You are supposed to face any answer face any question from among the subjects prescribed for study. Now, this Andhra Pradesh High Court in its notification prescribed 12 subjects in criminal law, 9 subjects in the 12 subjects in civil law and 9 subjects in criminal law. So, in these 12 subjects, 6 main subject, 6 small piecemeal legislations like Specific Relief Act, Easements Act, like that. And these 9 criminal laws subjects, some 4 main subjects are 5 small legislations like Negotiable Instrument Act, like that. So whatever it may be, I have uploaded uh, on more nearly 250 lectures on uh, 18 subjects. They are designed to LLB students from examination point of view. It is not possible to upload lectures on almost all the subjects over a day, over a month. So you take the help of those existing lectures on CPC, CRPC, evidence, transfer of property, contracts, negotiable instruments act, and all subjects I have given constitutional law, administrative law, alternative dispute resolutions, like that. I have given enough lectures. They are they are uploaded keeping in view the requirement of LLB students. You watch those lectures and then read any book and improve that for this examination. In course of time, I will increase the number of lectures for each and every subject. For example, previously on law of evidence, I delivered three lectures elaborately. It is equal to summary of the subject in detail in 3 classes. For average student, from examination point of view, those 3 lectures will give you an idea, overall idea on entire Evidence Act of 167 sections. With that, you read some book, it will be enough. It will easily, you will be able to pass the examination. So those 3 lectures are not enough for this judicial services examination. That is why I have taken up fresh the Indian Evidence Act, which is prescribed for this academic year only, this academic year, and all centers of legal education, all competitive exam centers for giving this judicial service examination coaching are following this. But even though the new act the act is recodified, but most of the provisions remain unchanged. The section number will be changed. Section will be changed. This aspect also I will explain in detail, dear friends. So I started this civil judge junior examination to improve the standard, to increase the number of lectures, to give latest developments. That is why, so over a day, even if I upload lectures in every day, you won't be able to follow. I sincerely suggest you, please subscribe my channel. As and when this notification comes, you watch that lecture immediately, and thereafter the pending lectures are there, nearly 250 lectures. Once in a one lecture in 2 days, 3 lecture in 2 days, like that you follow. Then it will be easy for you. Even if you don't get selected as a judge, you need not get disappointed. This knowledge will help you to be a successful lawyer, prestigious lawyer. I am telling you, my friends, my ambition is that I must if I'll be able to motivate some of the students in India to learn good subject and stand as a really as learned counsels. The judges call you as learned counsel. Learned counsel means even a lawyer who doesn't possess enough knowledge also is called, but you must be a learned counsel in reality is what my ambition. I want to make all sincere, unstinted efforts to enlighten you, dear friends. Here, so the number of subjects in Andhra Pradesh High Court notification, civil 12 subjects, criminal 9 subjects. Some of them are main subjects, some of them are this. So more than 50% of the subjects I have uploaded tentatively for LLB student. It is not possible for me to cover all these subjects for the coming examination. You may watch these lectures and read any book. You can comfortably follow and face the examination. So dear friend, this examination I told you, first you have to go through the preliminary examination. For preliminary examination, the syllabus and subjects varies from state to state. Some states more subjects are prescribed, some states less subjects are prescribed. Some states, Andhra Pradesh, constitutional law, administrative law is not prescribed. Some states, constitutional law, administrative law, ADR are prescribed, because constitutional law, administrative law, ADR are most important in legal profession. I have given good number of lectures on these three subjects, dear friends. I will continue this job so long as God blessed me with age and energy to deliver the lectures. I promise to spare my full time to upload many more lectures. Here I started evidence first because evidence is prescribed for study not only in civil laws but also in criminal laws. It will have double benefit. It will give you marks in civil law, and it will bring you marks not only in civil law but also in criminal law. That is why I have started this Evidence Act. This Evidence Act, old act I am following, and the new act also I will make a comparative study, because only section number change. There are no any major changes on this point. Of also I will discuss separately. So for preliminary examination, what you want to do is you study whatever subjects, whatever books you studied in LLB to better knowledge. Those home subjects, those books you can study for preliminary examination. For preliminary examination purpose, there may be guides available in the market. These guides contain all objective types questions as per the examination pattern. Suppose if you follow only exclusively these guides to mark A, B, C, or D, so you cannot have any knowledge over it, because this knowledge will not serve you any purpose for main examination. So for any objective type questions, you must read the total or entire subject from first chapter to last chapter. Then you will be able to identify the question. This knowledge will be helpful not only for the preliminary examination. This knowledge will be very helpful to your profession as an advocate tomorrow, judge day after tomorrow. So to prepare, suppose these all these subjects you have to read the respective books. Respect what books you studied in LLB, same books, same subjects you have to study thoroughly. So don't think that you each and every any in the nook and corner of the questions may be asked. They will not ask you, but you overall idea what are the most important topic, what are the most important sections, what are the sections and what are the areas that are generally even regularly we have to deal with in court of law. These areas only they normally question. They normally question in examination and viva also. If they question, if they go into detail in even one subject, it is not possible for merit student also to answer. You need not worry, dear friend. So for preliminary examination, you study all subjects. You whatever subject I have videos, you follow, watch my videos, and then read the books of your choice. Get ready. After reading this preparation, after completing this preparation, you should go to competitive examination guide, this objective types guide. Then after completing this subjective reading, you go for this guides objective type, because sometimes the old question papers questions may be repeated. Then after reading the subject type books, if read these objective type books in the last chance, then you will be able to identify the question and get to the preliminary examination. The preliminary examination is designed for shortlisting the candidates, yeah, maybe on 1 is to 10. The marks secured in preliminary examination will not be counted for selection. Main examination viva marks will be counted for your selection, dear friend. So every citizen means every individual, every candidate can appear for this civil judge junior division examination. They may go through the websites of various high courts to find out the notification. Some states conduct this civil judge junior examination every year. Some states once in 2 years or once in 3 years. So whatever may be, to be a good advocate, to acquire very good knowledge, sound knowledge, I sincerely suggest you to appear for the civil judge junior examination. Even if you neglected your studies in LLB course, you will get enthusiasm and inspiration to learn subject even after completing the LLB examination. If you don't get selected, you can go back to court with sound knowledge by charging good knowledge to your mind, and you can act as successful advocate. So this is for preliminary examination. Yeah, after preliminary examination, I suggest every student to take guidance coaching, not only for preliminary examination but also for main examination, because during the period of preliminary and main examination, you will be associating with so many candidates in the competitive examination center. They work day and night, more than 10 hours, 12 hours, 13 hours, 15 hours, even 16 hours a day. They go through each and everything. Having seen their performance, having seen their talent, you also will get activated. You want to work hard. All are doing very well, I also must do very well. That inspiration alone will take you to read more and more, work hard, and learn subject. So without learning any subject during studies, managing reading some book before examination, managing to pass the examination, going to court, you follow the senior, and you confine to particular area, you don't get any knowledge, dear friend. Even if you want to learn subject during your professional career as an advocate, you won't be able to find time, because you have to go to court, you have to attend so many things, you have to prepare so many documents, all these busy schedule you will have. That is the reason why I suggest you continue, extend your academic life for one more year in competitive center. As after 3 years LLB, 5 year course pre-law, the pre-law will not be prescribed for judges examination. Pre-law, history, economics, political science, and all, they are not prescribed for study. If they want, they can choose them as a optional subject for other competitive examination like civil service, group 1, group 2, like that. But civil civil judge junior examination, history, economics are not prescribed. So now coming to the next, So coming to the point, students are fearful that, so these are number of subjects are there, whatever we studied in 3 years, all the subjects are. Suppose in student career, to face five examinations, five subjects for particular one semester, you feel very heavy. Wow, five subjects, volume is very good. Volume is much more, and how we will be able to read. For preparing five subjects, you feel lot of burden. So to prepare number of subjects, 20 to 30 subjects, either for preliminary examination or for main examination, you feel lot of fear, because for facing five examination as a student in a particular semester examination, you are fearful. Lot of volume is there. How can I read all this volume? But when you feel difficult for five subject, what is the difficulty you will have to feel for 20 to 30 subject? For in Andhra Pradesh examination, 21 subjects are prescribed. 21, most of them are small legislation. For district judges examination, civil law 20, criminal law 15. 35 subjects are prescribed. So these any 7 years advocate, have advocates having 7 years standing, is qualified to appear for the post of district judge. According to Andhra Pradesh High Court, it is designed for in-service candidates. A civil judge senior division possessing 5 years experience is eligible. So the civil judge senior division possessing 5 years and above experience will have to face the district examination. How he will be able to go through 35 subjects during profession? He is in consistent touch with certain subjects only. He is not expected to have touch with all the 35 subjects. So in which subjects he doesn't have touch, he will have to go through all the subjects. He won't be having any time. He cannot be allowed to go on leave for a long time. Some practical problems are there. So that is why in such people also, they have wonderful knowledge and experience, practical experience, but in spite of practical experience, they must read particular subject to face the examination. In such candidates also, there is no wrong, there is no any they need not feel any inferiority and inferiority to watch my lectures or any other teachers lectures in net, for to save your time. And then after watching these lectures, they may go through the big textbooks and high standard textbooks of their choice. That is also there. So that is why. But why you, if you are very sincere in studies during teaching to student career of 3 years and learn the subject, you will not feel any fear to face 20 subjects or 30 subjects for main competitive examinations. If you have neglected your studies during the student career of 3 years, you did not learn the subject properly, you take some book before examination and completed the exam, pass out, and enrolled and started career as advocate, then if you face the judicial service exam, you feel lot of difficulty. That is why what I suggested is, you, any student, the perfect student, meritorious student, what he would do is, before going to college, what are the topics expected to be taught in college, he will give some slides for novel reading and then go to class, having with some knowledge. If he has some idea about that, he can have concentration in the lecturer's lecture. He will receive the lecturer's lecture very seriously, professor's lecture very seriously, and he will be able to develop the subject. He'll be able to present articles, write research papers and all. See, we have very good knowledge, very good knowledge. So those who do not prepare first, if any student watches me video on a particular chapter in 1 hour, and which will be taught in few classes in classroom, when once he has some knowledge in a particular topic, if he attends the class, teacher teaches, he receives the lecture with lot of enthusiasm and inspiration, he can have very good knowledge in subject. He can stand as one of the, he will be identified as one of the best students in the class, he will draw the attention of teachers and head of the institution. So to be very successful, very advocate, to possess wonderful sound knowledge, you read the book first or watch my lecture and then go to class regularly, receive lecture very sincerely, and then come out from college with handsome law degree. Then immediately you join competitive exam center for mock tests, essay writing, translation, crash coaching, and other old question papers review, and all these things. And then you will be able to get selected 100% as a judge. And even as a judge also, you must possess sound knowledge in various areas. As a lawyer, your knowledge in particular field may be enough sometimes, but as a judge, you are expected to have knowledge in various subjects, particularly in high court level and supreme court level. You must possess very good legal background, otherwise you won't be able to flourish as a successful judge tomorrow. So that is why this is the thing. So, firstly, what you do is study. You have to attend all classes, lecture, learn subject, competitive exam. Then appear for this preliminary exam. If preliminary exam is not fructified, you don't stop your preparation. Continue your preparation for main examination coaching. Either it will be useful. Suppose I did not get through for preliminary, let us go back to court. Don't think like that. Take main exam coaching to learn knowledge, to inspire your attitude to work hard. So that is my suggestion, dear friend. Naturally, I could not get through preliminary. Let us go back. So preliminary, you don't work hard, because they will do only. It is only confined to objective type questions. Other things are not there. But if you go to this main exam coaching, they will give subject coaching in detail. Others will read. You also will read mock tests. They will give guidance. Judgment writing, they give guidance. Essay writing, they will do these aspects. You can improve your vocabulary, language, talent, everything. To become a judge or civil servant, UPSC officer, your personality also will be tested. Your proficiency in English will be tested. Don't Your proficiency in English must be tested. That is why every candidate in India must speak English fluently, and he must be able to speak Hindi fluently. These two languages are very important wherever you move, anywhere in India. Hindi, like English, Hindi also is manageable in some countries. So that is why don't I sincerely suggest every student to learn Hindi and English, and must be able to speak fluently these two languages. So as an Indian, now, so this is why some states preliminary is almost common objective type test in almost all the states, but main exam, there are difference. The subjects prescribed are different. So the pattern also different from state to state. So overall, in whatever it may be, civil laws will be there, criminal laws will be there, viva or interview will be there. So in Andhra Pradesh, essay writing and translation is there. In other states, essay writing translation also is there. Some states, this essay writing translation may not be there. But so far as the current affairs, Andhra Pradesh examination, current affairs is not prescribed for studies. For some states, current affairs, legal aptitude are prescribed. Judgment writing is not prescribed in Andhra Pradesh examination, but judgment writing is prescribed in some other exams. This is the position. So what I want to tell is, you read all the subjects thoroughly, following one textbooks of your choice and learn the subject. For preliminary guide also, you have to go through objective type questions and then get to the preliminary. When once you get to the preliminary, you continue your preparation for a main exam. Even if you don't get through examination for a preliminary, as a junior advocate, don't concentrate, go back to court, because you are just came out of the college. Continue your, just like MBBS candidates will do house surgeon and rural service like that. After 3 year LLB, after enrollment, extend your academic career for 1 year, or 1 year or 1.5 year, by joining some competitive examination center to learn the subject and then go back to court. If you get selected as judge, you will go to court as a member of the bench. If you don't get selected, you will go to bar as a member. You go to court as member of bar, as a well knowledgeable candidate. This is my opinion. After 3 years of completion of study, whether you learned the subject well during studies or not, you extend your career by joining some competitive center in a high court headquarter. You start your career as an advocate high court and join there. If you have personal problems of business or cultivation or anything locally, you have to take care of the your family affairs, you may confine to subordinate court. You may continue to start your practice in subordinate court. This is my opinion. So here, next thing for this, so current affairs is common to every any competitive exam. Current affairs, so general knowledge will be there. Essay rating will be on some law subject. Essay rating will be given in alternative dispute resolution. Some essay rating is asked. One law subject, some essay rating is given. Like that, you can do all these aspects. A competitive exam centers will. If you have good subject, if you have good fluency in English, you are sure to become a successful advocate or successful judge. What I want to tell you. So, in main examination, you have to prepare like this. This is overall idea. What are the subjects asked? How you have to prepare. Main exam preliminary only objective type all question. Subjective books you read, and then objective type guides you read and appear for preliminary. If you get through or don't get through, you continue the main examination for 1 year. You spare 1 more year after your 3 year LLB study, and then you will learn essay rating, translation, judgment writing. You will face mock test. You will face previous question paper, and what are the areas that are generally discussed in court. You will get very good knowledge. With that knowledge, you go back to court as a member of the bench or member of. If you get selected as judge, directly you will go to court as a judge directly, successfully, without doing any practice. Otherwise, you will go to court as a successful lawyer. Then, where the successful lawyer, after 7 years, you can directly appear for district judge post. District judge post directly. Those who could not, who got selected as civil judge, may remain as civil judge senior division. But if you have wonderful knowledge, you acquire good knowledge directly. After within 7 years, you can successfully become a high court. You can successfully become a district judge. That is what I'd like to show. Ultimately, what I tell is, after 3 year LLB degree, you spare 1 more year for coaching in competitive exam center. Learn the subject very well. If you fail to study, concentrate well during 3 years, you watch my all lectures. You can get very good knowledge. Not only me, there are there are innumerable number of law teachers have given uploaded their lectures. High court judges, distinguished eminent advocates also have delivered lectures. Whose lectures you like better, you go through them and acquire very good knowledge to become a successful lawyer or successful judge. Next thing is books to follow. So many students are asking what books we have to read, what books we have to read. So, dear student, as an author of law books, I should not suggest you. I took into mind the requirement of student. I authored so many law books on various subjects. They are successful, but I, as an author, I should not suggest them. But what book is comfortable for you, you read it. In market, the books are of two categories. Main textbooks I'm telling. Some authors write the subject is section wise. Some authors write the textbook in chapter wise. Chapter wise. There are English authors, Indian authors. So if you have very good command over English, you can follow the English authors book or Indian authors book also. English authors books will have a high standard, commentaries also will be there. They will give you very good knowledge. That is. Indian authors also like Jain Pandey, Jain Pandey, Kailash Rai, M.P. Jain. Those very big books are there. They write chapter wise. So for examination, chapter wise is important. Chapter wise books you have to prepare. For advocate and judge, section wise are important. So some chapter wise mean you should take meaning in 4 5 lines. Even if you read the very big book containing 1,000 pages, you won't be, if any some side heading there is 1 page or 2 page, you won't be able to write all that big volume in the examination. Whatever area is necessary for examination, that area you have to collect and write in a working notes. Suppose in a particular side heading, one author may write 20 lines, one author may line 2 pages, one author may write some 10 pages. So that depth of knowledge is useful to you as an advocate or judge tomorrow. But as a student, you need not have that much information to be presented in the examination. If you present all that exam, there will be a number of cases with footnotes. For a particular section, there may be 10, 20, 30 footnotes are there. So these footnotes, any lawyer while dealing the case or judge while dealing the case from the textbook, he will search for the particular thing. Whatever case is relevant, he read over that, and similar cases, if any, he read over that, and then they take the citation and will refer the those citations. With the citation they will refer the judgments of that case. In judgments also of very hundreds of pages judgments may be there. If he is an advocate, independent advocate, he will search the relevant points to his case. If he is a big lawyer, he will entrust that job to some junior advocate, and that junior advocate will go open that AAR or other textbook or other book, and will put flag and mark the relevant area with yellow marker, and that is there I have seen. So that is why the merely because of the big books containing 500 pages, 1,000 pages and above, they are designed to give good knowledge, overall knowledge, wonderful knowledge to be an advocate or judge. Even for students of high standard also, you can manage this in national law schools and prestigious institutes of legal studies. Students also possess such knowledge equal to the lawyers also. They are required to, because they study in global schools, international schools. In schooling level, their English standard is very high. Their syllabus is very voluminous. With that experience, with the as a fifth standard student or 10th standard student, they are habituated to go through the voluminous books, so that they too will be able to go through these voluminous books. But the students studying in average students studying in average institutions, not having that much infrastructure, may go through these small books and manage. So cut the coat according to cloth. In the sense, you follow any book as per your standard only. When once you take for average students, I suggest you go for Indian author, first one. Secondly, latest book you take, read that particular year published book, and then for further latest development, you go through the internet for latest developments. Even internet also, latest developments means latest articles, latest research papers you should know. Sometimes you don't find, you have to ask the concerned advocate or concerned judge or concerned person for further latest developments. So even subject is common, natural subject, every law is formulated or codified keeping in view the ancient sources of law, shruti, principles of natural justice, good principles of dharma, all these things. The most of the portion in any textbook will remain unchanged for generations to generations. If any particular book is codified, it is not the process of 1 month or 1 year. It is the process of many years. That also I will discuss in detail. So for whatever book you read, you go to you take the suggestion of your senior friends or teachers and teacher, all what books others are following to. You go there, you go to bookshop, see the book, you verify the book, the content, first chapter, middle chapter, last chapter, the contents are suitable to your standard, and then you take that particular book, take home and take the book as far as possible published in that particular a particular year only. So there may be good books which are reprints, they also you can take. For latest development, you should go through the latest book or internet for latest developments. For example, if you take the constitution, the amendment is up to 95th or 96th. Today 108 amendment acts passed. Why is 128 amendment bill is in pending. So further meanwhile amendments may take place. So like that, you want if you say that old book in 97 amendment, if you write in 97th amendment, the teacher will laugh, anybody will laugh you. So that is why the latest developments also are necessary. Similarly, Consumer Protection Act, old act you follow, new act came. If old act you read today and speak, people will laugh in the court. That is why the latest developments are very important. Particularly in a interview, you will be asked to face the questions on latest development. If you don't have knowledge about latest development, if question is asked, the interviewed board will laugh at you like that. You will have to face this. Now, next point is criminal laws. Recently, the government of India, through the Honorable Home Minister Amit Shah ji, presented three bills in 2023 last year, August. Three criminal law bills, namely IPC, CRPC, and evidence, renaming them as Bharatiya Sanhita Adhiniyam, Saksha Adhiniyam, like this. These three, the three bills were presented in Lok Sabha August 2023. After several discussions, these three bills were withdrawn. These Sanhita bills, the Bharatiya bills, these three bills, second bills 2023, cancelling, withdrawing earlier bills, were presented in Lok Sabha, Rajya Sabha, and assented by the President of India in December. And these laws will be, after passing of these laws, there were so many comments from authorities for practical implementation. There are so many constraints. Basing on that, the government has issued notification for implementation of these three criminal laws with effect from 1st July 2024. Meanwhile, necessary infrastructure arrangements will be made by the government to that effect. These are the this is there. So in so far as whatever, even though the three IPC, CRPC evidence are recodified, most of the provisions will continue. Previously, so many laws were recodified. In Companies Act 1956 was recodified in 223. the implementation of the, if you see any Company Act book 2013, in every area, whatever the provisions were there in Companies Act 1956 are being repeated in 2013 Companies Act. In every author has written this particular provision was explained in section 25, previously section 22, like this, like that they were writing. Today also, tomorrow also, race guest day section 4, previously section 6, interpretation clause section 2, previously section 3, like this. Whatever is there, the contents are mostly same, because any law is drafted not in one day or 1 month or 1 year. It will take much time. Much time. For example, I tell you, it will take much time. For example, the codification process was initiated. Codification means in India some laws are codified, some branches of law are codified, some branches of law are not codified. Indian Penal Code 1860, it is codified, because when you speak Indian Penal Code, we will speak in sections or subsections. When you speak law of torts, you don't get any sections. Some wrongs are torts and crimes. When you speak defamation in Indian Penal Code, section 499, 500 you speak. When you speak defamation in law of torts, there is no any section. That is why if the subject is not arranged in sections, subsections, clauses, we say that it is not codified. If a particular subject is prescribed in sections or articles like this, we call it as codified. Indian Constitution comprises of articles and clauses. It is codified. IPC is codified. CRPC is codified, like this. So that is why. So when these laws were passed hundreds of years back, for example, Indian Penal Code was passed in the year 1860. It was applied to both India, Pakistan, even after independence of Bangladesh and all. Today, Indian Penal Code 1860 means how many years? 1920, 140, more than 250 years. Indian Evidence Act, more than 250 years. 250 years, so same law followed. When any law is to be codified, suppose law of torts is not codified, suppose it is to be codified, a proposal to that effect is given to Law Commission. The Law Commission will take into, appoint a committee and chairman. These people will go into through so many areas, so many, they go take natural principles, principles of equity, Shastras, Dharmas, all subject aspect, what are the laws in neighboring countries, how the position, all these things that they decide. Suppose Indian Constitution, when Indian Constitution was drafted, Government of India Act 1919, the Government of India Act 1935, they took other Swiss Constitution, West Germany and other countries' Constitution, they have taking into consideration all these acts, all these other countries, then they drafted this Indian Constitution under the chairmanship of B.R. Ambedkar ji. Then ultimately the Constitution bill was presented in November 49 and came into force 1950. So the Indian Constitution was passed in 1950. Now how many years elapsed? 1950, 2000, 75, nearly 75 years elapsed. So again also it has 128 bills are there, amendment bills are there. 128th Nari 6th bill providing reservation to 33% to women in Lok Sabha and state assemblies has been ratified by assented by President of India, and it will be fructified in next elections after getting it ratified by all the legislatures in various states. So like this it is there. So that is why the codification, the process of codification, so that is why don't think that evidence Bharatiya bills, Bharatiya enactments came, IPC, CPC, IPC, CRPC evidence are no more. Never think that whatever is there in IPC, CRPC in evidence are being repeated in the new act with certain changes only, because changes are inevitable, incompatible, because so the long day today we are in a computer world, we have so long back if anybody wanted to telephone they had to book trunk call. If you book trunk call in post office today, the call will come tomorrow late night, tomorrow or day after tomorrow late night. In those days the people were booking lightning calls, 3 minutes 350 rupees in those days, 80s. Today, anywhere in India, if anybody was in America, the parents had to spend thousands of rupees to telephone to speak to their children. Today, with no expenses, everybody is able to speak to their near and dear from America and other distant countries in video call. So, owing to changes in the socio-economic conditions, these laws need change. However, it is not so easy to the authorities, a government of India, to change. As a matter of fact, almost all legislations in India have several amendments. IPC has 78 amendment acts and 576 acts. Evidence has 28 amendments followed by 2021 act and 2022 bill, more than 30 amendment acts, and Indian Evidence Act. And that Indian Evidence Act originally 166 section, 167 section, 28 additional section, 185. In this new Bharatiya Sakshya Bill, Satya Adhiniyam, it has 170 sections. In fact, 15 sections. You think that 167 sections, 170, 3 sections not increased, 15 sections reduced, practically speaking. So like this. So the actual, for example, I tell you what a difficult process of to is. Actually, the codification process was initiated in the year 1833. First Law Commission was appointed in 1834 under the chairmanship of Lord T.B. Mokhale, and Second Law Commission in 1853, Third Law Commission in 1861. So the codification process initiated in 1833 got fructified in 1861. How many years? Nearly 25 years. After 25 years. So if law is not codified, so many problems, so confusion is taking place. Laws must be codified. To that effect, the Charter Act of 1833 made a proposal, made a initiation for codification. That codification took so many witnessed so many dimensions and changes, and ultimately the proposal for codification was initiated in 1833. A law commission was appointed in 1834. The last 19 enactments were codified during third law commission period, that is 1861, or that is after 61. So don't think that codification is not an easy. The government may have, every government is busy with so many affairs, their personal issues will be there, welfare activities to be implemented, they have to justify the all classes of people, they are very busy with anything. So at the same time they won't be able to pay their full concentration on the enactment of laws. So otherwise even Indian constitution is there, it also needs to be codified, and almost so many laws which have drastic changes need to be codified, but it is not possible. We have more than 1300 central legislations, innumerable number of provincial legislations, uncountable number of local legislations. So these only 2019 29 labor legislations were proposed to be codified into 4 labor codes. These 4 labor codes, the bill on 4 labor codes was presented in Lok Sabha 2019, but they have not yet become law. Consequently, I wanted to upload labor law. I wanted to revise the labor law textbook, but this matter was stopped. But here also, those who have prepared these laws, revised these 3 textbooks, have stopped publishing the textbook and waiting for the waiting for the 1st July. For after successful implementation, the books will come. So that is the reason why don't think that if new laws came, old laws have gone. Never think that, even though the section number may be is changed. For instance, repealing act is section 2. That repealing act is section 170 in new evidence act under new chapter. So many these issues I will teach you in detail in the chapter. Similarly, an Indian Evidence Act was proposed in the year 1835. That is Act of 1835. Thereafter, 10 legislations were passed to codify. Then one eminent jurist, Sir Henry Maine, his bills also failed. Ultimately, lastly, Sir James Fitch, he made it. So it got fructified. So the proposal to codify Indian Evidence Act was made in 1835. The act came in when 1872. So many years, 35 to 72, more than 35 years elapsed to bring the Evidence Act into operation. So that is why, dear friends, when once a law is changed, never think that law is totally changed, that law is no more useful, like that. So those laws will come in the same concepts. The Dharma Sutras. What is law? What to do, what not to do. What to do, what not to do. So even if you don't do what you ought to do, but you must not do what you ought not to do. So what I have to do something. If I don't do, it may be negligible. What I must not do, if I do, it is serious. Law will take cognizance of the person. So to help somebody, you have to do. Even if I don't do, help somebody, it is a logical obligation. The good. So the legal obligations and logical obligations are there. If legal obligations are fulfilled, the law will take cognizance into the issue. If what one must not do, if he does it, law takes cognizance of that particular omission. So these are the issues, and these developments also I will tell you. These criminal laws and all. And the next thing is classwork. Dear friends, you are thinking that for competitive examination, nearly 20 to 30 subjects, you feel lot of heavy. You need not worry, because it is natural when you are a student in law. When examination comes, barring backlogs, first semester 5 subjects heavy. Say any first year or say first year to final year, the student has to face a semester exam comprising of 5 subjects. 5 subjects he feels heavy. He doesn't. His fear vanishes, because before exam he feels 5 subjects. When he prepare for a particular subject, only one subject will be in the mind. Tomorrow is IPC exam. Only IPC will be in his mind. Remaining 4 will not be there. When he writes the exam, that particular question he is answering will be in his mind. So the fear will gradually vanish. You need not worry. Like that, having completed 3 year course, you are supposed to possess knowledge in all the 30 subjects. Yeah, then only you can comfortably face the judicial service exam. Even if you neglected your subject learning in student career, then the next dais is competitive exam center. You spend your 1 hour, 1 year in competitive exam center, learn from preliminary to main examination. In college, your classmates may not be serious in studies, but in competitive examination, every candidate appearing for exam will be very serious about exam. Everybody will be running with time. They want to learn more and more. Everybody wants to supersede the other. There will be, after lunch or dinner, they sit together, they will pose question. Everybody will be able to answer the question. If you cannot answer the question, you feel guilty, and then you go back to room, work day and night, and get yourself equated with all the students. That type of inspiration, enthusiasm you will have in competitive examination center. That's what I suggest you to join some best competitive center for 6 months to 1 year and learn wonderful knowledge. And if you get selected as judicial officer, go back to court as a judge or go back to court as a successful advocate, well knowledgeable advocate. If spare one more year for law course, 5 years you are working. For the law course, 3 years or 5 years, you are, graduates 3 years, 12th standard people, the 5 years sparing. You spare one more year in competitive exam and get yourself charged with wonderful legal knowledge and go to court, go back to court as a lawyer, go back to bench as judge, go back to bar as lawyer. This is what my sincere advice, dear friends. So now that is why the next attending the classes is a very difficult job. I regret to express that my classes are 1 hour, 1 hour and above. The students may feel lot of difficulty because, dear friend, when I take up the giant project of number of subjects, unless I take lecture for 1 hour, I won't be able to complete the syllabus. So you think that if you are supposed to attend 5 periods of 5 hours or 555 minutes in any class, would practically how many colleges first 5 hours are conducted, how many colleges the 5 hours students are attending is a question. Whether how many classes are being conducted, how many classes are being attended by the student, is you know, oh, practically. Anyway, you are supposed to attend at least 2 to 3 classes. In some institutions, the teacher first 2 periods will be attended by the one teacher. In Maharashtra, where I worked as principal, two classes are conducted at a time. Third hour, some other man will come. So when I studied evening college in Andhra University, first 2 periods were attended by one teacher. Third period was attended by some other teacher. Even in the third period also, so many students go away. They attend 2 classes in third period, they go away. Some where the timetable is up to 5 periods, 3 periods they attend, fourth period or fifth period they may attend. If the institutions run the classes very strictly and the students are penalized or punished strictly, in such cases the students may be constrained to stick on to the classrooms for 5 hours. To for successful completion of 5 hours class, there should be morning session and evening session. Then only it can be possible to attend, to motivate the students to attend five hours. Is my personal experience. Some prestigious institution they may be able to do that much because morning one so many institutions today are running 2 shifts. Morning shift one college, afternoon shift. Morning law college, afternoon women's college or day college like a degree college like that because accommodation problem. So that is why when one single shift is there, in single shift attending 5 classes consecutively is not an easy job. So that is the thing. Dear friends, some students are asking, I have uploaded nearly my books. I have taken every care to write a meaning, definition and all these things. My books are good for average students and all. Even merit students also take the help of my books, read my books. For latest development, I suggest you to go to latest textbook and internet for latest development. But I have take given limited information. So some of my books are 300 pages, but I did not if sex don't think look down at my books as small books. They may be my books are around 300 pages to 400 pages. If I write in a section wise, I will have to add all. I will have to add all entire Bayer Act. It will be 100 to 150 pages. For every section wise, if I add a number of cases in footnote from other books or other sources, it will my books will come to 1000 pages also. If I write my books instead of chapter wise, if I write my books as section wise, first I reproduce the section from Bayer Act and Bayer Act contents and illustration, then explanation and supporting case for each and every section. 5 cases can be given, 550 cases also can be given. If I increase the number of cases, can be simply for that I need not do any work, carry forward from other sources any book or any textbook footnotes are common in almost all the textbooks. So it doesn't come with the meaning of this copyright. So that is why I have whatever book you follow, if we read the book of 500 pages or 5,000 pages, but I sincerely tell you is to read, to make working notes, write meaning in few lines, definition one or two definition, that enactment definition you write, conditions, and you read. Even if you read big book, after 20 pages wonderful sentences will be there, you collect those wonderful sentences. You read article, if I read article, I reading article of 30-40 lines, I get one or two sentences only. All articles content is almost same. Everybody will write on a particular article, same matter. But some others write wonderful English, some other write wonderful points. So whatever wonderful points are there, I collect and place before you. Place before you. So that is why. So a book as a subject as a whole common, but different authors will have different style. Some authors we are having some special style, specific style. That special and specific style and specific sentences we have to collect and present, but our work will be very good. So that is why my students may read my books, Raga Surya Rao's books available everywhere, online also, but I suggest them, but my books are not updated, revised, but you have to go through the latest book and latest developments for this what is called internet also. Latest article you have to prepare, still some latest article also, the updated information may not be available in some cases. You have to take the advice of concerned judge or concerned lawyer. So that is the another day. Lastly, I want to tell you, some students are asking, why have 250 videos? Oh, subject wise, it is difficult to know. I request the student friends place my videos in playlists. I shall be thankful to you. You are helping not only me, your colleagues also. You colleagues also. That is here. It is difficult to find out your lecture in out of 250 videos. You some may feel. So, dear friend, what you do is, I have uploaded my videos, lecture videos in YouTube. You open the YouTube mic, you touch the YouTube mic. In phone, you touch the ring, then YouTube will come. YouTube some mic will come. Mic will come. You touch the mic and ask, Raga Surya Rao, law of evidence, admissions, that will come. Raga Surya Rao, criminal law 1, IPC, murder, that video will come. Raga Surya Rao, law of torts, defamation, you can say, defamation video will come. Raga Surya Rao, law of torts, negligence will come. Raga Surya Rao, alternative dispute resolution, you ask, Lok Adalats, it will come. Raga Surya Rao, ADR, fast track courts, you ask, it will come. You are experts in this computer knowledge, I need not tell you. You touch video, YouTube mic, touch mic, call my name, call the subject, call the chapter, that book will, that video will, if we uploaded, it will come. If it is not uploaded, you may get the videos of some others also. So that is why you need not search all 250 videos to pick out the video which you like to have. So this is there. For books, people say that my books are available in the publishers and also online also. You will have, if you touch Google and mic and ask Raga Surya Rao law books, my books will come with a number of innumerable number of websites, number of publishers are there, they will give you. Please note, dear friend, I write books, not very big personalities, High Court judges, Supreme Court judges write books, not for money. But the money we get is nothing, absolutely nil. So competitive Copyrights Act, author is everything, is every word is favorable. But agreement with the publisher, every word, every letter is favorable to publisher. We never get any income. That is only we pay 30% consistently. We don't get even 3%. Whatever we earn, even for valuation also, working whole day, the 30% will go to income tax. So that is why we do service for our satisfaction. Long back, I circulated the study material of around 30 pages for all the subjects. Whatever discount Xerox man gave, not printed, that discount I gave to bookshop people and gave circulated the books through states of Andhra Pradesh and Telangana, two states, Telugu states. So service is more important. So anybody may think that what is this Rega Surya is doing all this for nothing. But this is a great opportunity. God has blessed me with an opportunity to serve the thousands of people all over country. It is not, we cannot get, if I get 1 crore, nobody will see. If I do this service, everybody will see. I will be, my name will be visualized, my service will be visualized. Even if I go, my name may continue even after my death. I will have the satisfaction that even some of the students also remember my service. If I little get whatever little I get from this YouTube for 2 years, 3 years, some few thousand, I give it to some temple. Do not have some financial aid, or give to some poor people. So I don't need this money. This is for academic videos. I don't get anything, dear friend. I'm suggesting the student. I am not giving any requesting them to you subscribe, do this, not that. But I am requesting the student. My service should be utilized by maximum number of students. I am telling my student, you watch my video just 5 minutes, download it and share it to your friend. So I am given to understand that number of places students are downloading my video in 5 to 10 minutes and sharing it to all his friends and entire classroom. So directly I have 15,400 subscribers. Know about my videos, and indirectly many thousands of students are availing my videos. What more I require? So my service is being utilized by many students, even students of prestigious institutions of legal studies also are following my lecture. They may follow, anybody may watch my lecture first and read the book as per their standard. Even teachers, junior advocates, anybody, there is no wrong. When I deliver lecture, I watch the video of some student. After a student, I read the article. At that time, that student will be my teacher, my guru. So the one should not feel any hesitation to, nobody should feel any inferiority complex. So even a senior teacher who never taught a particular subject in his career, if he is asked to teach that new subject, instead of going to very big books directly, first they watch my video and book, and then they go to big book of their standard and status. Then they will be able to save a lot of their time, dear friends. So, for lastly, I want to tell the student, dear friends, you must first stand. Some students say that English problem. English, any language, if you do practice only, you can learn English, you can speak Hindi. So no language, if you with interest only, if you learn any language, you will be able to speak that particular language in 6 months to 1 year. If you have no interest in that particular language, even if you stay in a particular area for 10 to 20 years, you won't be able to learn that particular language. I could learn English speaking in 6 months. I would not able to learn Hindi and Marathi fluently, despite my stay in Maharashtra for the last 20 years, because I'm otherwise busy with my office work, service, books, reading, all these things. I'm not able to concentrate. That is my reason. If I have concentrated, yeah, as I could not speak Hindi fluently, I'm not able to upload lectures in Hindi. In case I would be able to speak in Hindi, I would have uploaded all these lectures in Hindi also. The number of there will be thousands of subscribers for Hindi. My service would have been communicated to thousands of law students all over the country. So, if not knowing, I feel that I'm very unfortunate. I won't be able to speak Hindi. Otherwise, I would have uploaded here all my videos in Hindi also. So any subject, if you learn in your mother tongue, you will be able to understand very quickly. Even though a student is very well, has wonderful knowledge in English, if he listens if he is listen to any particular subject in his mother tongue, it will be deep rooted into his heart and mind. So that is different. That is different because suppose Hindi, I may manage Hindi, Marathi, I have only 50 to 100 words. But the other man of Hindi or Marathi, he will have 100 crores of words of Marathi, Hindi. He can use anything. That is why any subject learned in mother tongue will be useful. But however, as per the directions of Bar Council of India, we must write the examinations in English media only. So that is why if at the same time one must not confine to mother tongue and neglect English. If I have seen some people, great officers, retired great officers, they during their service of 30 to 40 years, they did not get an opportunity to speak English. They totally forgot English. They are sometimes they are unable to speak English, are unable to understand English. They were a wonderful English spoken great postgraduates. Great postgraduates occupied good position because of the reason that they did not get an opportunity to speak English for 3 to 4 decades of their service. They are rendered helpless to speak in Hindi. That is why any language we have to speak regularly. Every language is great. Every language is an asset. That is the reason why our former late Prince Sir P.V. Narasimha Ji was acknowledged as great person for the reason he would be able to speak almost all Indian languages. Wherever he addressed the gathering, he used to address the people in that local language only. So that is important. So dear friend, please learn. Yes, try your level best to speak English and Hindi fluently. If your mother tongue is Hindi, you are lucky. But if even once your mother tongue is Hindi, you must concentrate English and speak fluently. You should have personality also. Your talent in English is tested. Your mannerism, conduct, and everything are tested in interview. The way in which you are speaking, the way in which you are answering question is not important. The way in which you are answering, the way in which you are speaking to elders, that is interview board, also will be counted for your selection. And another thing is, so shorthand is a great art. If students, your children, if you are able to learn shorthand, it will be very helpful and useful to you. You can, when you attend the seminars, conferences, and everything, great personalities will address the gathering. If you are able to note those speeches in shorthand, if you are permitted or not, I don't know. In court, instead of spending here or there in court, when you have no brief, you go to one court chamber, court hall, and in which area you are doing practice, in that area a eminent lawyer is presenting argument. You go there, you listen to that eminent lawyer, how he is presenting the case, how the judge is responding. You listen to them very carefully. If there is no provision to record their conversation, you may do it in shorthand. Do shorthand if you are permitted. I don't know. I never entered court also. Then the same practice you can apply and similar facts and circumstances, you also can become such a great lawyer. Great lawyer. Tomorrow, how the what are the arguments he is presenting? For those arguments, how the judge is responding. That talent also you can collect from the judge. And tomorrow you can be a great lawyer. Day after tomorrow you can be a great judge. So that is how you have to spend in court, because instead of expecting all these things from senior advocate, you have to learn yourself. When a senior advocate, eminent advocate is presenting an argument, you should learn from him by sitting close to his in the chamber, and you also listen to very carefully how the judges are responding. So that if you follow these, practice these things, tomorrow you can apply the same techniques as a lawyer and judge this thing. So this is shorthand. Lastly, dear friends, computer is very essential. I think every one of you must learn computer. But without computer, you are a person, you are unfit to write anything on the paper. When once the students today do not understand, do not have typewriting, computer operation, they are helpless to write, because almost all exams are online, public application submission is online, everything is made online. Office work previously table, files and everything, but here any office, that chair, table, computer are there, no files are there. So that is why computer today is sine qua non. Every student must learn one course in a computer. That is important. Shorthand you can get, if you will help you a lot. And typewriting also you should not, if you can do typewriting. Typewriting today is updated. But dear friend, if you spare 3 months and appear for typewriting lower test, whether you pass or not, it is immaterial. First pay, speed will be there. That speed will help you for computer typing, will increase your speed. And in second paper, there are so many statements and everything. Script, when you type scripts of written scripts, you can understand. When you write a letter, where to give spacing, how to maintain spacing, where to start, where to end, a subject where to write the presentation of letter in a systematic style. You will be able to know the presentation of corrections of various variety of correction, variety of statement, how you will be able to get them corrected in proper line and then type. You will be able to know if you know the typewriting. This is an official task, office work. As an officer, you will have to, if you know these things, they will be help you. The typewriting, I am not asking you to learn typing to become a typist. You people feel that not that. My brother suggested me to learn typewriting and examination, not to become a typist, but to learn various technicalities of official letters and all. So this is with these few words I take leave, dear friend. Thank you very much for your patient hearing. God bless you.